Yeah.
So it is. Okay, cool. So
So you're
we're
going to
still
talk about Rule 26, John?
no. Yeah, actually I am. You can add to what I'm saying. So I just want to speak generally, but yeah, you're welcome to add and talk about the rules if you want to say, hey
Yeah,
John, there's this thing in the
all
rules.
out of here.
So let me just I'm not gonna show you my notes yet because I know you're gonna be reading ahead and not listen. I know. I've been there. So there's a couple things going on. So I deal with a lot of situations, okay? And so I'm going to give you a couple scenarios. So if I'm dealing with a situation where I don't want my business partner to have to testify about some matter I'm dealing with because it's annoying, and the business partner freaks out and I can talk to the client and I can explain all the detail and then he'll understand and he'll be calm and he'll work with me. But if we get his partner gets pulled into a matter that we're dealing with effectively, and his partner gets pulled in, and I haven't had that conversation with him, and he doesn't care about the conversation, he's going to be a little miffed or afraid, as we've seen before. And so there are ways to exclude that person so that, for example, if I'm dealing with a matter and I'm doing quite well, and my business partner, for sake of investigating assets, gets pulled into discovery in the civil proceeding that I'm involved in, that he's not involved in, and that our business relationship is not involved in. But this is how these creatures operate, okay? So they get a deposition notice, right, to my partner, which he can easily be discovered on public records. So we're going to get to the point of how we can address that and defeat the discovery effort, even if the judge wants to order it, okay? There's always a show cause order, and we can justify why he can't be called. And so there's a couple core things, and I'm just gonna move into this real quick. So the discovery, so let's call it discovery. It's when we're in a civil proceeding, and I'm saying it this way because this is probably the worst case scenario, right? If it works this way, it's going to work everywhere else, even in an IRS audit. And we'll get to that. Please remind me, by the way. Okay, John, how does this all work together with an IRS audit? Please remind me if you would when I get towards the bottom here. So my note is like number 6. So anyways, so we're in court. Someone's seeking discovery, and we want to have a plausible basis why a person cannot be deposed or cannot be required to answer certain questions. So if someone asks them interrogatories or written questions or produce documents or subpoena to produce documents, the great defense would be, I'm sorry, I don't have control or custody of such documents. Now, if you are the custodian of the organization, for example, you can't really say that. If you're today the custodian of the organization, and let's say today you get served with a discovery request of that kind, you could produce a letter of resignation that was dated from last week. Now, I know that sounds deceitful, but you can do it and get away with it. That's one example. The follow-up to that, which you're going to have to participate in, is to use that to argue that you don't have control or custody because either you were fired or resigned on such and such a date. Even if you can argue that on the date you were served with the summons, you were fired because you were served with the summons. And I say it that way to answer some of your questions because I know you guys have hypothetical questions. So you could plausibly do that. And yeah, they would know it's bullshit, but they'd have to accept it because they can't make you go get the records. And you could say, well, I tried to get the records, but they wouldn't give them to me. So then the question is, who'd you give custodianship to, right? And then it becomes the original, it goes back into the lap of the client I'm working with, for example. That's where we want it. We want the fight with the client I'm helping. We don't want innocent parties being harassed. This is what I'm talking about here.
Right.
So imagine if you had certain documents. Let's say you're running a company or a partnership or something, and you have certain important records. Namely, it's going to be financial records, right? And so someone's trying to get those records to do something, make a conclusion, or have a follow-up subpoena to do something, or apply to the court for a writ of levy, for example. That's why they would want these things, right? So if the records relating to my financial affairs are within the custody of an attorney or a law firm, but there would be an attorney involved, then they would be subject to the attorney-client privilege. Now, there are certain conditions on this, right? But generally speaking, for the purpose of this call, you could use a law firm and or an attorney to establish attorney-client privilege. Now, I'll show you how I use this. Now, this is not what I was talking about with the IRS. Well, let's see. Let's say IRS, administrative summons, okay? Administrative summons can be enforced under the Federal Rules of Civil Procedure under Rule 27. So when you have a summons, you have to comply with it because it is under a court order, but yet it's not in court yet. You still have to follow along with it. But again, you still have this defense of forget Fifth Amendment. That doesn't work. What you need to do is you can identify that the particular question, you can't
No.
just do everything, but the particular question is subject to the attorney-client privilege. So many times where my client does not need to go to the audit to justify an expense or deduction of some kind, that he just can just go to the audit and not risk having to disclose everything because there's no benefit for him to do that. We can actually tell the IRS that they only get to see what's on the four corners of the 1040 that were filed, okay, the tax return, because that was testimony. It was under penalty of perjury. And that additional records, if they want to do a third-party summons to your bank, okay, can't help you there. There's no legal basis to stop that. But if you come in there, and I've had clients come into the IRS audit, and the first thing the client says, as what I instruct them, is to tell the agents that they're only going to get he'll only answer questions that are the answers of which are on the 1040, nothing more. And that's the end of the audit. They'll quit. So the consequence of that is the IRS sends an examination changes notification, right? At 4549 or something like that. So if you're okay with that and your deductions are good and you're not going to get any better, well then great. Now you don't have to risk disclosing everything else because you understood how to use the attorney-client privilege. Now, whether or not you have an attorney is actually irrelevant. It's nice to have one, but you don't even have to have one. You could be a liar. That works. Okay. Yeah, there is one thing I wanted to mention. I set up this connection to this accounting firm out of the country, but you can the connection to the accounting firm is not working. The accounting firm's still out there, but I can show you to get the same benefits, and I may reestablish that in a better way that I won't lose control of it. So that's coming. We could talk about that too briefly. But anyways, the way you bring records for the custodianship. Now, this works in many situations. Let me just mention, for example, if you're being liquidated in family court, and if you're following my videos, you should know what I'm talking about. This is a very unique, kind of weird way to explain something. So you have to follow my videos to understand this. So if you're being liquidated in family court, you want to fight. This is a war, okay? You're not going to get the court to follow the rules. They're going to try to liquidate you. What I mean by follow the rules is they're going to overstep the rules of everything to conduct a receivership. They're going to apply the rules of involuntary receivership in a family court proceeding and not tell you. Okay, so they will not be following the rules that they should be following, just so you know. So the rules of receivership are anything goes, just so you know.
And they'll get mad at you if you call them on it.
Yeah, it's like calling him the name. See, Judge, you're operating in involuntary receivership. You're the acting receiver. Oh no, I'm not doing that. Okay, then what do you call this? Because for whatever reason. So this also helps when you have custodianship with a law firm. Now I'm going to show you there's different ways of doing this. So let's say you could be subject to discovery. Now I'm going to make this easy for you. Here's a strategy you can use. You don't actually need to have the law firm, okay? It helps to have, in other words, you don't have to actually use the law firm to have the actual records that you want protected. All you need is a law firm to take custody of some important records that you don't want to be subject to discovery anywhere, okay? All you need is a law firm to have a custodianship agreement with you, and I would have the law firm write the agreement. Now, some law firms will do this and some will not. Some will only do this for active clients where they're doing litigation or something or some business writing, okay? But you want to find a law firm that will take custodianship of paper records. And so you put some paper records, which could be blank pieces of paper, okay? Or it could be actual paper that you maybe want to leave for your family, right? In an event where they have to go get them if you're not available. You put those in a fire resistant or fireproof bag if you can find one, fire resistant, and you seal that you just seal that bag because they can make them seal. And then you put that inside an envelope with a tamper-proof seal. You can buy those at Amazon or probably your office supply store, okay? You want a tamper-proof seal, that's very important. Then you can put that into let's say a briefcase or something convenient, something nice, and then you make your agreement and say the contents of this are within the custody of the attorney. He doesn't need to know what's in there. He should not know what's in there. Now, anytime you're asked for certain records of anything, you get to say, I can't give it to you. It's over there. My attorney has it. He may not have it, but how can they say that he doesn't have it? Because the attorney doesn't even know if he has it. And even if he does know what he has, he can't tell the other party. The court has to accept it at face value. You understand? The attorney-client privilege is so powerful. This is how we can use attorneys. Someone asked me today, it was yesterday, it was a call, and she had her house in probate. And it turned out that it shouldn't have been a probate, and there was an attorney involved. And I said, you need to fire that attorney and report him to the bar. How the heck is it getting you in probate when it's not even a property that was of the deceased? Oh my gosh, don't get me started. So you don't go to an attorney when you don't know what to do and ask him for help. He will take you to the cleaners, as you know. At least have a clue, okay? So this is what I'm saying. So you have practical steps. You have a secured packaging, fireproof, because you don't know what's going to happen in that office, right? And it should have a security seal on it, right? Security, what do you call it? Proof, right?
Tamper-proof seal.
Yeah. It has all kinds of purposes. All right, so let's see. Yeah, you don't want the attorney to represent you. You just want to take custody. He's not doing litigation. That's his only role, okay? You want it to be separate from any other matters, in my opinion. All right, so this gives you the idea. Now, you can also have a custodianship agreement. For example, you can use attorney-client privilege. You can have the attorney, write the scope of the agreement. There's all kinds of things you can do. Now, one of the things I have done in agreements like non-disclosure agreements, or wherever it makes sense, is to have a large liquidated damages clause. So this is where either I have an attorney type situation, or I just have a contract for privacy like non-disclosure agreement. Okay, lawyers are generally not going to let you put a $250,000 liquidated damages clause in there for a data breach. Because they're going to think, well, we're not going to breach the data, and that's too much liability for us. But it's nice to have it in there. The attorney will let you, but if not, fine. If you have a non-attorney relationship, like a custodianship going on, if you have liquidated damage in there, it gives someone plausible deniability or a plausible reason why he can't disclose it unless you're going to indemnify him against the penalty. So if someone says to you, you must give us these records, and you say, okay, but if I give them to you, then I'm not permitted under the contract, and I would be subject to this large fine, this penalty. And unless you're willing to pay that fine for me, I'm still not going to do it. Sometimes that works. Sometimes it doesn't. It gives you something you can work with, okay? And of course, you want to make sure that, and if it's a good law firm or whatever, good contract, that there's a successor trustee or custodian, okay? So that way you're covered, because you don't know what's going to happen to those people. All right. And then the next thing we get into is the protection of chattels, okay? Property like furniture. When I say chattels, I'm talking about, for example, things in your household, right? So chattels would be like, for example, you could list things in your household, things that you care about. Let's say furniture, appliances, electronics, jewelry, okay? And you want that document. I'm not saying you need to show it to people, but you have a document like an inventory list of things in your house that you care about. And then there could be, this is how you work it out. You set up a mailing address, and I would use the name of where it receives mail in the name of trust number 56, just so that it can be verified. We don't care about the trust documents, and don't ask me about all that stuff. We just need a mailbox where you're the mailbox holder, and mail is sent there and will be boxed if addressed to trustee number 56, for example. In which case, when someone asks you for things, or someone's trying to compel you to produce or give up or sell or dispose of or something, that chattels in your household, for example, you can explain that it's not yours, right? Just like if you rented furniture, right? You couldn't be compelled to give that furniture up for sale, right? Because it's not yours. It has to be returned back to the company that rented it to you. So if the trustee is the ownership of this property, the trustee can be contacted through this mail, right? So the mail gets sent, the demand or whatever gets sent to the trustee, not you. And the trustee can deal with it, which really you can deal with it. But in the name of the trustee, they don't know this. So you have a bit more like a separation, right? So that way you can't be compelled to do something which is out of your control, is what I'm getting at. Okay. And this you can do without an attorney or law firm, and so forth and so on. I mean, you can be using that for discovery. You can also use trusteeship for custodian of records. You can just set that up. You can just use a PO box. Okay, it's pretty simple. All right, and then so for example, let's look at the idea of a data breach. So if there's a data breach, let's say, for example, let's say, here's what I tell clients that I'm working with, and they're in the middle of discovery, and I can't prevent it. And so when the discovery takes place, we immediately change the information. Like, for example, the bank account records, right? If the bank account records were already given up, like the account information and things of that nature, let's say it was already given up before I got there. Or let's say we just did that to get past the discovery question, and we simply change those records. Now, I know you'll have a lot of questions after that. So you can change the records, but that gives you a leg up on the next thing that's going to happen. And I don't know what that is. That could be, you know, there could be all kinds of, but it might take months and months and months for them to figure out that's what you did. And in which case, it just, there's more iterations of that idea. Okay. So you're not just stuck. All right. Don't act like, I got stuck by the weather. It rained on our parade. You know, you have control over your data for the most part. Okay. You can do things. We can retitle property. We can change a mailing address. We can close compromised accounts. Compromised accounts are when the account information is disclosed for some reason, maybe by force, but you were compelled. You can change it. Now, I know there are some court orders that penalize you for changing things. So that is on a case by case. You got to think that through. I'm just speaking generally, okay? What you want to do to a discovery request, generally, so I'm thinking, let's say I get a discovery request. My first thought is I'm going to ask for a protective order. Now, if my client's being deposed and I just got the case, first thing I do is most of the time, the person is being deposed and he didn't even think to do a deposition of the other side. That's what you always want to do is you never give your deposition by yourself. So what I will immediately do is ask for a protective order. And if you ask for a protective order for any reason, it's granted. It doesn't matter what the reason is. The motion filed for protective order grants the protective order, meaning that you don't need to show up at the deposition. You don't have to tell the other side. In fact, I've seen lawyers file a motion for protective order after the date for deposition. So not that that's a good idea, but you can use a protective order, asking for a protective order to get protection, excuse yourself from going to the deposition. Now, what will happen is the other side will bring it up before the judge and you'll have to deal with it at that time, which can be done, but you'll have time. You'll buy yourself time. You might get like 3 months of time, you know, might get 2 months, something like that. And it's worth it. And so here's what I'm thinking. You can go to sometimes you have to go to the deposition, okay? And you can be coached on that. There's strategies, but if you have written discovery, you can also ask for protective order. But what I recommend on written discovery, on item by item, is you go item by item and you give a reason why you're not going to or not able to answer the question. And I'm not going to get into all the details because it's a bit of an art to know what those are. But generally, my recommendation is you want to respond to each question by answering it with an objection, possibly. Sometimes you can answer it partially and then object without waiving your objection, right? You answer without waiving your objection, then you make your objection. So I recommend that over the motion for protective order if you don't need the protective order because it's written discovery. Because if you ask for a protective order, the judge will just deny it, right? Just deny the whole thing. So why not just make them argue each and every point, right? Each and every objection you have for however many questions they have. Sometimes it's tedious, but it's worth it. All right. Any questions on that? Or something come up?
Yeah. The question is, how do you change records? Could you give an example? It's one of the things you were talking about just a moment ago.
Change a record. Oh, like
You
for
know,
example, bank account. Just close your account, open a new one. Mailing
Oh,
address.
okay.
Yeah, change your mailing address.
Okay.
Yeah, or get a second one, keep the other one open, right? That way it doesn't benefit them to know that. Change the articles of association on your company. And by the way, I tell my clients, keep your name all the same, keep everything the same on your companies. They can discover all that stuff, but they won't be able to get any property because the way your company's protected, how it works. But when it comes to other things, sometimes it makes sense to change the account information.
So when you say change the account information, you mean legitimately change
Yeah,
it?
just
You
close a
don't
bank
mean-
account and open a new one.
Okay.
Yeah. Yeah, so I treat court order disclosure, if you have to give it, as a data breach. And so it's a security risk. I was threatened under penalty of contempt. I had to give it up, but because I'm responsible for the data, information, money, I therefore have to change. Okay, that's the idea. All right, so, and then subpoenas, same idea. So subpoenas, if you can, determine how the subpoena would be served. So that's what we do. That's what we're doing with the custodianship agreement. Notice, you give notice about your address, notice about the address of the location for certain records if you're testifying. So that's why it's beneficial to have a PO box that can receive mail in the name of trust number 56, for example. That way subpoenas are sent that way, right? I don't know how they would serve a subpoena on a trust at a PO box. That's an interesting quandary they would have, right? So what I had mentioned earlier was if your innocent partner is summoned, you don't want them being, harassed. Now, some people they want to get involved, but if a person doesn't want to get involved or it's a nuisance, you can pretty easily defeat the subpoena or the depot notice or the whatever summons or interrogatories or discovery request by responding saying that I no longer have control or custody of the record you're seeking, or you can answer each and every question this way. That's generally how it works. And what's the reason why you don't have control or custody? Well, let's see, I was either fired or I quit long ago, something like that. Or I have this liquidated damages clause, right, that bind me to paying a huge amount of money if I disclose it for any reason, and there's been no consideration for judicial process. Most lawyers, when they write a contract, they say, yeah, but if a judge says you have to give it, you have to give it, no penalty. So don't put that in the contract. You might have to get into disclosing the contract and this sort of thing. But I'm just giving you some ideas here. All right. So anyways, I'm not going to get into the conditions for the contract. I would just say if you're going to have a contract for the custody of records, I would have the custodian write it, provided that that person is a lawyer that has a practice in that area, that does that service, okay? Now, you could probably use a lawyer. He'll understand about custodianship if he doesn't normally do that. I wouldn't say most lawyers do that, but they do it as a matter of course anyways, not deliberately, but they do it because they have to, because the client needs that type of service, right? But you'd have to find a lawyer or a law firm that has this service and just pay for it. All right. I haven't priced that out, but you can just consider that as something you might want to look into. Now, yeah, anyway, so there are some terms and conditions that qualify for the attorney-client privilege. So it's not just a panacea that you're just going to automatically get it. You will get it, but sometimes it can be defeated. So you got to be careful on that one. Now, I do have a video, and I'm going to put the link here. I'm just going to put this last part of my notes because that's all that's really needed here. I'm going to put this in the chat. This video is explaining what you can do if you are called in to testify. And the way I frame this is in a case where you're being liquidated, like in family court. I'm showing you how to use subornation of perjury to destroy your testimony as you give it. And let the judge has to accept it. There's no way he can avoid it. And so he looks like a fool. And you never have to tell the truth. In fact, I'm showing you how to lie and tell the judge that you're lying and make him liable for it. It's their own rules. So subornation, okay, so to suborn testimony is where I use my official office to order someone to give testimony. When that moment occurs, my first statement under my testimony when I swear in is everything I'm about to tell you is a big fat lie. And that's how I would say it. The reason being is that if you don't testify, if you're being told, and this you have to qualify, judge, if I don't testify, am I going to be held in contempt? And what does that mean? And if he says, if you don't testify, I'm going to put your ass in jail, you say, thank you very much. I will testify under threat, duress, and coercion. And here's what I'm going to, first statement is that anything I say henceforth is a big fat lie. And you should be aware, judge, of the terms and conditions for subornation of perjury. And he will not like that. And he'll probably end the hearing right then.
So subornation means that you protecting yourself by telling them that everything you're going to say.
That's how we're using it. But to suborn one's testimony means that if he lies, the one who suborned his testimony using his official office is liable for perjury. So if the judge tells you you have to testify or else, you tell him you're going to lie, and he still makes you testify, he's liable.
Okay.
It's like the Inquisition.
Yeah. Well, the
Where they
Inquisition,
put you on the rack and they said, tell us, the truth.
well, they'll just kill
on the
you then.
rack. Yeah,
But
yeah.
I mean, this way you just kill the judge's bot. I mean, you're not going to kill him, but
Wow, this is
yeah. So
fantastic.
look it up if you guys want to look up subornation of perjury. SUB right? O-R-N-A-T-I-O-N, subordinate, to suborn one's testimony. So anyways, I have a whole separate video. It's like only 6 minutes or something somewhere. I forget where I put it, but there's that. It's in my materials too, in my course, but I just want to go over this here now. I'll just leave you with this. When I do work for clients, and this information comes from like 30 years of doing this work, okay, taking thousands of audits and post-judgment discovering all kinds of ugliness, okay, over the years. And so I've come up with these methods that I will apply as needed in different cases. So I just want to give you an overview of kind of how I look at things. Who did what when, what's at stake, and then I look at the rules, and then we actually just use the rules. Nothing, no theories there. I don't use any form letters. I make it up as I go with what I just showed you. It's like learning martial arts, and then you don't know if you're going to throw a punch first or a kick, right? But you know martial arts, so you just got to do what's needed as it comes up.
Mhm.
All right. So I hope that's interesting. I know it's a boring subject, but I know a lot of you guys probably.
Oh, it's not
No.
boring.
All right, well, I'm glad to
Never-
hear that.
You're
I've
never
experienced some
boring,
of it.
John.
All right. Yeah, it is useful. I mean, especially if you're watching the news and you're hearing about these people and these things happen. Like I watch the news and I'm listening to like the court proceedings and I'm like, what the heck? Why'd they do that? They didn't have to do that. Oh, that's right. They had an attorney. You know? So just realize that's going on. Yeah, okay, the False Claims
Oh.
Act, Batman. All right, look, so just briefly, and I'll go into more detail. I have the pleading, by the way. So what this means is you can sue. We need to go after family court, y'all. If you have a cause, if you want to have a cause, if you don't have a cause, choose this one. Sue your state. There's a notice requirement under the Tort Claims Act. Sue your state under the Federal False Claims Act for money it's received under the matching fund scheme under Titles 4D and 4E of the Social Security Act. Now, how much are you going to assume for? You know what? You could just make up a number. If I were you, I would just make up a number and see what I get. Maybe I can sue him for $1 million. You'll find out that's nothing. You could probably sue him for $100 million. I don't know about 100 trillion, but I would assume enough for something that would cause the ability to get a settlement. Now, here's what you're doing with this law. Okay, we could do that, Tom. With this law, what's happened is the US government decided that there's a bunch of people out there like us, that if they have knowledge that there's some political subdivision like the state or something that's getting federal money and it's doing so making false claims, that they're letting us police that. And they're allowing us to file a lawsuit for the dollar amount we believe has wrongfully been paid out to the state in the name of the United States of America. You can represent the United States of America, and you can do so in the amount of the principal amount you're claiming, plus, let's say, treble damages, 3 times the amount. So 1 million plus 3 million, right? And I don't know, you're not going to get the whole thing, but you can get a third of it, right? Let's say a third of it. So if you quadruple a claim and you get a third of that, isn't that more than the claim?
Mhm.
So yeah, if you're trying to recover money, let's say, for example, you were a victim of a liquidation in family court 2, 3, 4, 10 years ago, and you sue for the amount of money you've been paying in child support and alimony, I think it's fair game, isn't it?
Mhm.
Anyways,
Trouble that. Yeah.
we have a remedy, and I don't see a statute of limitations on that. Of course, why would there be? Why would the United States put a statute of limitations on its own self? So, all right. I like this number, though, 100 trillion. Shoot. I don't know if that even exists. All right, I'm gonna go, y'all.
Okay.
So fast.
Hey, what
Okay.
about, did you cover what you said for us to remind you about, number 6? or
Okay,
something?
so for the IRS, I think I even mentioned it.
Okay.
So for the IRS, if you don't have a need to justify an expense or something to get a deduction, if you just, like, for example, when I try to negotiate with the IRS, if a person hasn't filed returns and we need to file, then we file with no deductions, only standard deductions. And we make the debt as high as possible, okay? Then you're going to go through an audit in that case. And in which case we're going to go and tell the IRS that, what you see is what you get. And I'm not going to give you any more information than you've already got on my 1040 or that you could get through third-party summonses, because it doesn't matter. So that would be the only thing I was going to mention. I wasn't sure if I was going to mention that during the presentation. So yeah, sales tax. All right. Tax exempt status for what? principal address, tax exempt status from what? Federal income tax?
Sales tax?
Importing, okay, importing, exporting, you're fair game for that. I'm going to tell you right now, I'll be the first person to say you don't have to pay income tax on such and such. But when it comes to import, export, as far as I know, everything you're going to be taxed. That's where a nation can get you. There is no way around that one that I understand. It's the income tax primarily that we're talking about. Now, sales tax, I can probably do sometimes. It does alter how you're pricing things though, but I don't even talk about sales tax too much. Only sometimes when it's in the matter of doing something else. But import tax, you're not going to be able to outcompete someone on that one. You got to do it. All right. Yeah, stop doing, nothing's due on the beneficial owner information reporting. Don't do that. Yeah, thanks, John. I got your message. Yeah, there's no BOI requirement, y'all. I don't even care about these other guys, these lawyers, these stupid lawyers that are talking about the other stupid lawyers that beat them on the Fourth Amendment application. It's unconstitutional. I know it's unconstitutional. I was telling you guys why it's not legally binding, assuming it was constitutional. And these lawyers are stuck on constitutional. They're still stuck in kindergarten. I don't care. But either way, BOI is not required. So what I would like to do is I may just I have the pleading on suing the state under the False Claims Act. I may just put a course together on that, okay? And then you guys can learn from that. All right?
Go at it.
I'm gonna let y'all go. Thanks for
Thank
joining.
you.
Appreciate it. Happy New Year, by the way.
Happy
Thank
New
you.
Year.
Same
Gonna
to
be a good
you.
year,
Thanks, John.
2025. All
Have
righty.
a great weekend.
See y'all next week.
Happy
Thank
New
you.
Year.